to work alongside her. So without further ado, we're going to turn it over to her. She has lots of information for you, but she's also available for some Q&A. So think about questions you have for her. And without further ado, Mr. Dale McDonald.
Sister, we're ready when you are.
Okay, well, thank you. I gave a great talk. I'm sorry you all missed it. I hit screen share and it was all over, but I had my phone silent, so I didn't see it. So I'm sorry for any confusion, but I'm happy to be joining you at this time to talk about some of the policy issues. You know, as the Vice President for Public Policy, I work with a number of other organizations, USCCB, the Bishops' Conference, the Council for American Private Education, Agudath Israel, the Independence NAIS schools, the Christian schools, the Missouri Lutheran schools, a variety to all advocate together for advancing private school interests before the legislative branches of Congress, the White House, the Federal Communications Commission, other agencies, Department of Ed that deal with issues that impact our schools. And basically our premise is first, see that they do no harm, and then secondly, try to get included. So I'll go through quickly, given the time constraints, some of the national education issues impacting our Catholic schools. I'll talk a little bit about the political climate in Congress and the Department of Ed, the pandemic relief packages, the Build Back Better Act, federal aid to education and continuing the equitable services, a little bit on religious liberty, and then an important school choice case that is coming before the Supreme Court. So on the national landscape, we are dealing now with a situation that is different from what we had the last number of years. Both the Senate and House, as well as the White House, are controlled by the Democratic Party, which means that the chairpersons of the House and Senate Education Committees are Democrats, very much into public school issues. And we've had some contentious relationships or non-relationships as they have tried to cut us out of a couple of programs and made it difficult for us to be connected to the national education agenda. The Secretary of Education, as a former public school person, both at local and state levels, his focus is primarily on equity, inclusion, which of course we would sponsor, and opening of schools, which we are concerned about as well. He's non-committal on charter schools, definitely opposed to private school choice. The Biden administration priorities are on childcare and preschool, which we're very concerned about. The higher ed affordability and student loan forgiveness. A big part of the education agenda was free community college. That got taken out of the bill for financial reasons. And the student loan forgiveness, that has moved to a kind of an executive order out of the Department of Education. And I'm not going to go through this quickly. You'll get these slides at the end, but they've now changed the rules, the regulations, and the availability of the public service loan forgiveness, so that if you're working for a 501c3 nonprofit, as our schools are, you might be eligible to have your loan forgiven for your service as a teacher, administrator in a school. So it's a time constraint on this. You have to apply by the end of next October, and more information is there on the website URL at the bottom of the page. The COVID relief packages are what we're having some issues with, and are hoping that we can get cooperation to improve our participation. The original CARES Act was first hint that all was not well for us. in that CARES bill, we expected, since it was a relief package, to be treated as we were in all of the other retreat packages. I go back to Katrina in 2005 and how we were equitably treated in that for relief for all schools, all kids. We found out quickly after the Department of Ed put out its regulations, guidance rather, that we were in trouble, that the public school groups all coalesced together, and with the chief state school officers, the public school superintendents, or whatever they call them at the state level for public schools, file suit against the Department of Education. And in the end, we had to be treated in that program as we would be under Title I. And while the public schools could all participate, our participation was really restricted to participation in Title I attendance areas of our students, significantly cutting the kind of funding we were expecting. In EANS, the CRSSA, the EANS 1 package, the supplemental, there was an attempt, a serious attempt to get us cut out of the program, us meaning private schools when I say us. And in the compromise in that was the 2.75 billion. While the public schools got 54 billion, we got 2.7 to engage in activities that would help to promote educational opportunities for our students during the pandemic and provide a safe and healthy environment. In that bill, the priority was, it was written into the bill that the priority was to go to low-income students and those impacted by COVID. But you were not allowed to apply if you had gotten the first round of PPP, the Payroll Protection Program loans. The myth continues to prevail that, we're all wealthy schools, we don't need anything, we're taking away from the public schools, et cetera, et cetera. And so for our schools, most of our schools were able to assure that the priority was given to low income, but that there was room for all to participate, and that the COVID impact was very kind of loosey-goosey, that you could claim, that you did not get the expected funding you would from your fundraiser because you were closed, or so many tuitions, or so many were not paid, or students withdrew and impacted. So you could make a case how impacted you were by COVID, and it was accepted. In EANS 1, any funds that were not expended were to go back to the GEAR fund. Looking over at the first column, the GEAR fund, the governor was given $3.3 billion to use for whatever the governors decided they wanted to do in their states. And if any of that money went to K-12 education, then our schools had to participate equitably. So that GEAR fund is still operative. And if there's money left over in EANS 1 or 2, it goes back to the GEAR fund. But once it goes to GEAR, it's no longer EANS money, it's GEAR money. And so the EANS restrictions don't necessarily apply. At least that's the tack we're taking. And then in the second, in the American Rescue Plan package, that's the big bill that put 122 billion into public schools and 2.75 into private schools. Also, there's a 2.6 billion supplemental to IDEA. So if you're if you are participating in IDEA, the money that your district gets should include you additional money. That's both public and private school. That's not a 2.6 just for IDEA. The problem with the EANS 2, where we had some really strong resistance, was that the law requires that a school must have a significant number of students in poverty in order to be able to participate at all. And that significant determination was given to the Department of Ed to make. And so the Department of Ed made a 40% poverty rate, the significant number, unless the state governors were to change it. If a governor wanted a different percentage, they could ask for a waiver from the department and go with that. We've seen in a couple of the proposals that have been approved and are out, a number of states were able to get that poverty count down to 20%. There's a lot of pressure on governors from state Catholic conferences and state lobbying groups to get that count lowered to a more realistic explanation of how poverty has impacted or how COVID has impacted our schools. But the specific COVID requests, data requests, are problematic in a lot of cases. You no longer can determine how COVID impacted your school. You have to follow the guidelines that they put out. And it really deals with getting data about how COVID overall impacted your local community, number of cases, number of deaths, et cetera, et cetera. So you've got to do some digging in public records to get that information. Again, it's not allowed if you have sought new PPP funds and the funds go back to GEAR. So there's going to be a significant amount of money most likely left over when states, especially when states have the 40% poverty. So that pressure is now being put on governors again, and you should get your parents even to schools and parents to appeal to the governor that the GEARS money that was appropriated, the EANS money that was appropriated and has now gone back to the GEARS fund should be reserved for private schools issues as the appropriation had intended them to be. So we're trying to get more information on how schools are successful or not in getting the EANS money. We know in some states they're having a big issue in California where the state has lagged really in what it's trying to do for implementation of EANS. The CARES Act money was to be administered by the local LEA, the public school district. The EANS 1 and 2 are administered by the state education department, the SCA. The other big issue we're looking at right now, and the only issue that Congress really is looking at, is the Build Back Better Act. That's the Biden program for the reconciliation budget bill. And we're looking at the child care piece of it, the universal pre-K, and the technology. I'll just dispense of the technology quickly. The Commerce Committee has put in a request for an additional $4 billion for the Emergency Connectivity Fund. That was the fund, hopefully, that most of, or if not all of your schools applied for this summer, where the FCC was giving money for schools to be able to provide laptops, tablets, hotspots, equipment needed for students, and in some cases for teachers, low-income people who lack the ability to participate effectively in the virtual learning experiences, so that many schools were able to provide, between the CARES money and hopefully EANS 1 money and now the connectivity fund, money to be able to supply students with what they need. The $7.7 billion that was originally in the Emergency Connectivity Fund has almost all been expended, and they're looking for a permanent $4 billion fund. However, as they're fighting over going from 3 trillion for Build Back Better to 2 trillion and maybe less, this looks like it's very shaky in terms of being included. The thing we really are concerned about is the child care program. They're looking from birth to 5 as part of this Build Back Better provisions. In the child care, what they're looking to do is to expand the Child Care Block Development Grant, the CCBDG. That's a certificate program that's administered by social service agencies, that of the Health and Human Services, and our Catholic charities deal a lot with this, where low-income families who are looking for childcare, particularly while the mother as a primary caregiver would be trying to get job training or looking for a job, et cetera. So they get a certificate to present to the child care provider, whether that's a public entity, a private entity, a private entity or a faith-based entity, or where many of our schools have participated, have students who come to their pre-K 3, pre-K 4. It's, it's pre-K, not the kindergarten programs that can use these grants. The problem with the new program going forward, which reflects the attitude of Congress, is that they apply the non-discrimination statute, so that if you are getting one of these certificates, you cannot call upon the exemptions in Title IX, Title VII, and 504, which we are granted. And you have to really operate as a public entity. And so that's problematic for us. And then also there's language in the bill that makes the recipient of the certificate, the school who gets the certificate from the parent, a recipient of federal funds, which also negates the exemptions in particularly Title VII and Title IX. The universal pre-K also applies the non-discrimination statutes, and the basically requires you to secularize your program. No religious content can be part of the program. So you either do religion after the program, before the program, or not at all. And so, both of those provisions, the non-exemptions and the secularization piece, are, poison pills for for most faith-based groups who are providing these services. And 53% of the pre-K programs, the child care programs, are run by faith-based organizations, which means it will be a major withdrawal of providers. The purpose of this bill is to increase the number of providers, and yet by some of the language that, and I have to say in all candor, it's very well known on the Hill that becoming a recipient of federal funds or secularization of the program is a non-starter for ours. And so, while we have made the case and lobbyists are working on trying to get language fix in these bills, we may in the end not be able to do that. The bill is moving very quickly. They've been trying to get it passed for the last couple of days. And so we're looking at a potential crisis in childcare if we can't participate. The other is the continuation of the preschool, of the participation in the regular title programs, the ESCA programs. And so our focus all along and continue since 1965, basically, has been the equitable inclusion of our students. So we know the format, the child benefit theory, the public trusteeship, where the services are provided to students and teachers in the form of goods and services, not financial aid to the school. Not only does the law prohibit direct financial aid to the school, but our willingness to become a recipient of federal funds is at play here. And so the programs provide the services. The government agency, the LEA, for most of the programs, does control the funds and pays for them so that we don't touch the money. So if your schools are not receiving the services now, they should be. And if they aren't, you need to consult with the LEA to make sure that the program is started in a timely fashion. By now, it's no longer timely. And I'll let you read that on your own when you get the slides. Well, what does it mean to be equitable? It means to be basically similarly situated students and teachers are treated the way their peers are in the public school system. This is becoming a bigger issue now, the whole notion of the Religious Freedom Restoration Act, religious liberty in our schools, and ways there are pressures from various publics to limit that. The RFRA, the Religious Freedom Restoration Act, protects religious freedom from federal interference. And basically, what it says is that the government should not substantially burden your free exercise without compelling justification. And this is where it's starting to get messy on what is compelling justification. The original intent of the law was that the government could interfere. It was necessary the furtherance of a compelling government interest, which directly relates to core constitutional issues. And this is where we're seeing pressure now regarding sexual orientation, gender identity issues, and government's interest in promoting equity and in redefining what sex means. But even if they do interfere, it has to be done in the least restrictive way. And that's again up right now, that's kind of up for grabs. Primarily the two major pieces that we're looking at are Title VII of the Civil Rights Act, which prohibits hiring discrimination. But there is an exemption with respect to employment of individuals of a particular religion to perform work connected with carrying on of such activities if it violates a tenets. And the same in Title IX, which is basically the education program. Civil rights in hiring is under 7, education is under 9. Again, that you can't discriminate based on sex, which had different meaning at the time this was put into play, but that there is exemption for religious beliefs, that what is asked of you would be in conflict with that. For both of these, you don't need a special exemption. The exemption is built into the law. The civil rights deals with the protected class. And these are the pieces up here are the protected class. You cannot discriminate against people in employment and in other areas based on these status. What has happened in the last number of years is that the executive department, the president, going back to President Obama and now to President Biden, and the Equal Opportunity Employment Commission has said that sex now includes sexual orientation, gender identity. I'm talking so quickly, I'm sorry. That we refer to generally in the law as SOGI. And what we're seeing, particularly going back to what we were looking at with the childcare and universal pre-K, the objections to changing the language, well, we're just using, standard language, so that the SOGI is becoming in the mind of many, particularly lawmakers and staff, that sexual SOGI is now the current language, and it just applies, period. And that's what we're looking, in the Build Back Better Act, to try to get some clarity on the exemption still applying. But the Equality Act that's before Congress now, which did not get passed in the last go round, but is still operative in terms of potential for law, would specifically eliminates Title IX and Title VII regarding SOGI. So we're set up here where we've got, people of firm religious conviction and people who are looking at that conviction as discrimination and in tension with one another. And we're seeing that play out in a number of particularly legal cases. So that what's important to keep in mind is that state governments can't do less than what the feds say, but they can do more. And in some cases, they have really put SOGI statutes into play in states way before the feds did with the recent proclamation. So we have here a number of cases in which the religious liberty issues came up. The house on the table was you can hire for mission. The Hobby Lobby and the Masterpiece cake shops say that your religious beliefs can control, sincerely held religious beliefs can control whether you bake a cake for a same-sex couple marriage or not, or whether you dispense or provide for birth control for people in your employ. The Espinoza decision was the big Montana school choice case, which said you can't not have if you have a program that provides tax credits, scholarships, etc. to some, it must provide to all, regardless of religious status, so that you're not impinging on your free exercise. What the Montana case said, well, if I exercise my right to go to a private school, then you're denying me a tax benefit. Scholarship. Guadalupe and St. James were also schools that really said that church governance, church doctrine governs, and the Supreme Court was not going to second guess them. In Fulton City Fulton versus the city of Philadelphia, this was where Philadelphia was denying child care providers, foster care placement, adoption, etc., if you would not entertain placing children with same-sex marriage. And the court decided that that was a violation of the free exercise again. One case that has thrown a wrench into a lot of what's going on is the Bostock versus Clayton County in Georgia. And that in that case, the Supreme Court said that that the term sex as defined in protected class does include supportive SOGI. And so now we're looking at a couple of decisions above that said that religious belief would prevail. And now we have Bostock saying, well, sex does include SOGI. And so we're not sure where this is all going. And we've seen in some of the school cases at local levels where teachers have been dismissed for same-sex marriage, people going back into court at the local level to fight that based on Bostock. And then the next decision that will be December 8th at the Supreme Court is Carson v. Macon. And that is challenging the Maine statute. Maine says that the Espinoza decision doesn't apply to it. Maine has more than half of Maine high schools. Maine districts don't have a high school, that they will pay for students to go to a high school in another district that does have a high school. Again, sparse population is a problem here. But you have to be in going from a public school or into a public school or into a non-sectarian, but they will not spend the money on a faith-based school. And they're saying that it's not free exercise, but that their constitution says you can't support religious content. And so Vermont also had a similar case, and they were dickering around about, well, how much should we pay if we're going to let them go to a faith-based school? Do we pay half? Do we pay 40%? And the Supreme Court told them to get on with it and just go forward. And so we're looking to see, getting into this Maine case, will the fact that some religious content might be covered by the tuition change how we're looking at particularly Espinoza. So this is a big case. This could go either way, because if they're going to start prohibiting subsidy to content, then a lot of the state choice programs that are operative may be in jeopardy. And so, I have it's a hard stop at 4:30, so I have 3 minutes. What's important is that we are transparent about who we are as Catholic schools, how we address human sexuality and teachings of the church, and that no one has a right to come to our school. No one has a right to work in our school, and that we want faculty, we want support of school student and parents for the mission of the school. And, it's an interesting phenomenon to see that parents are paying big tuition for a Catholic school education. And yet when a teacher is let go for violation of church teaching, they're out on the picket line supporting the teacher and not the school. And so we've got to be really clear about who we are. And this slide here, you can read it on your own, has what is the actual teaching of the church on marriage, homosexuality, gender identity, gender dysphoria, that deals with transition, sexual transition as well. So that's what decisions are based on. So for our own schools, in terms of how you're dealing with the SOGI issues, particularly, you've got to have clear matters, that of course, the bishop is the final authority, and you go with what the bishop says in terms of keeping your identity as a Catholic school. But the school mission statement, the codes of conduct, and all of your application and for admission and employment reference the faith-based nature of the school and the expectation that the mission and purpose of the school will be supported by those who are part of the school community. School choice, again, this is a big issue going forward. These are all the states where there are some publicly supported programs. The only federal one is the DC Opportunity Scholarship, which keeps coming up under challenge. Current administration wants to let it run out, no new ones, and finish out. Of course, there will be a lot of lobbying, particularly from parents, on that issue. So just a couple of words about, when you're designing school choice programs, the important thing is that the right of the school to operate as a Catholic school must be protected. And here is my contact information, available by phone and by email. And even, I sometimes do presentations for diocesan, at a diocesan invitation to go into detail on these programs or the federal programs. And I think I have fulfilled my obligation to finish in 30 minutes. Sorry for the blitz. I hope I didn't speak so quickly you couldn't understand what I was saying, but I will send this and you will get the slides for your own perusal and anything you want to call me on and check on. So thank you very much. Sorry for the rush.
No, thank you. It's also great she's been jumping on the monthly calls with everyone because there's been lots of Q&A happening in those monthly superintendent calls. And so keep those coming as well. So thank you, sister. We'll see you soon.
Okay, great. Have a good rest of the evening and presentations. Bye.